Let's start with some quick background on the history and purpose of CEQA. CEQA was signed into law in 1970, at a time when the country was waking up to the need for environmental protection. CEQA was modeled after the National Environmental Policy Act. Before CEQA, large polluting projects could be approved without regard to the serious harm they caused to the communities and the environment. As former Senator Byron Scher famously said, CEQA became Californians' Environmental Bill of Rights. CEQA requires that public agencies disclose and mitigate the impacts of proposed projects before they are approved. During the CEQA process, public agencies receive input from the public about the project, how it will affect their communities. CEQA is our look before you leap law. Decision makers should know the effect of their land use decisions before they make those decisions, before it's too late to prevent harm or mitigate negative impacts. CEQA is designed to improve projects, not stop them. The CEQA process has resulted in better, more sustainable projects throughout the state. We will show you specific examples of CEQA's work, cases where the statute made a marked difference in every region of California. CEQA has three main elements. First, the lead agency for a proposed project must disclose the project's potentially significant environmental and public health impacts. The purpose of this feature is 1. To assist governmental officials in their decision-making about projects that might cause harm, and 2. To inform the public about projects that could adversely affect their communities. How are these impacts disclosed? There are three main environmental review documents. 1. Negative declarations are very short, consisting of a statement that the project will not cause any significant impacts. 2. Mitigated negative declarations acknowledge that a project had potentially significant impacts, but the impacts have been eliminated or reduced to a level of insignificance. 3. Environmental impact reports, also known as EIRs, are used when a project has the potential to cause significant environmental impacts, and these impacts have not been mitigated as part of the planning process. Since CEQA was adopted, it has been amended to ensure agencies are not required to conduct duplicative or unnecessary environmental review. For example, agencies can now tier their environmental review for specific projects off earlier programmatic EIRs that were prepared for broad planning documents like general plans. Full EIRs are therefore now quite rare. They are used only for major projects that have the potential to cause significant harm to public health or the environment. For example, one study showed that for all housing projects in San Francisco, there were just 7 EIRs in the 3-year period from 2018 to 2020. The second major element of CEQA is the mitigation requirement. Here, the lead agency must identify feasible ways to avoid or reduce the significant effects of the project. This mitigation requirement applies only to a project's significant effects, not to every small effect. Mitigation is the heart of CEQA. It is how the law improves projects. The third major element of CEQA is public engagement. CEQA is the only state law that allows for public input on land use decisions, and it is this public engagement that improves projects. Critics sometimes suggest that CEQA be replaced by a standards approach, where developers would simply fill out a checklist of requirements. But such an approach would deprive constituents of their right to have a voice in their community's future. CEQA allows members of the public to get involved in land use planning in a number of ways. Residents can follow public notices about particular projects, comment on environmental review documents, attend public hearings, and organize with their community. CEQA has important safety valves. First, the legislature has exempted many categories of projects from CEQA altogether. Indeed, most development projects in California are exempt. We will discuss specific exemptions for housing and infrastructure later. Second, even if a project has significant impacts that cannot be mitigated, the agency can still approve the project. The agency just needs to adopt a statement of overriding considerations that gives reasons why the project should move forward despite its environmental effects. The reasons can be economic, legal, social, technological, or other reasons, and must be based on substantial evidence. Agencies frequently use this mechanism to approve projects. This presentation was brought by the organizations shown on this slide. These groups are all supporters of CEQA Works, a coalition of more than 200 environmental justice and conservation organizations dedicated to protecting and preserving CEQA. Thank you for your time today. If you have questions about this presentation, please contact one of the 4 people listed here.